Hello, everyone, and welcome to Internet Law Review. For today's story, we have the case of Kisor versus Wilkie. This is a case that had been long expected this term because it's dealing with something called Auer deference and whether or not that should be overruled. Under a prior case of the United States Supreme Court called Auer, the Supreme Court had ruled that an agency gets deference when interpreting its own regulations. This has been controversial because an agency can change its interpretation without changing regulations, and so therefore can change what the regulations in practice means. This case gave the Supreme Court an opportunity to review that deference and to decide whether it should uphold. So we're going to read this decision, read a little bit about what it says, and understand what the court had to say about this deference. Let's read on. Petitioner James Kisor, a Vietnam War veteran, first sought disability benefits from the Department of Veterans Affairs in 1982, alleging that he had developed post-traumatic stress disorder from his military service. The agency denied his initial request, but in 2006, Kisor moved to reopen his claim. The VA thus agreed that he was eligible for benefits, but granted those benefits only from the date of his motion to reopen, not, as Kisor had requested, from the date of the first application. The Board of Veterans Affairs, a part of the VA, affirmed the retroactivity decision based on its interpretation of an agency rule governing such claims. The Court of Appeals for Veterans Claims affirmed. The Federal Circuit also affirmed, but it did so by applying a doctrine called Auer, or sometimes Seminole Rock deference. Under that doctrine, this court has long deferred to an agency's reasonable reading of its own genuinely ambiguous regulations. The Court of Appeals concluded that the VA regulations at issue were ambiguous, and therefore deferred to the board's interpretation of the rule. Kisor now asks this court to overrule Auer, as well as its predecessor, Seminole Rock, disregarding the deference those decisions gave to the agencies. This court's deference doctrine is rooted in a presumption that Congress intended for courts to defer to agencies when they interpret their own ambiguous rules. The court adopts that presumption for a set of reasons related to the comparative attributes of courts and agencies in answering interpretive questions. But when the reasons for the presumption do not hold up, or when countervailing reasons outweigh them, courts should not give deference to an agency's reading. The court has thus cabined Auer's scope in a variety and critical ways. First and foremost, a court should not afford Auer deference unless, after exhausting all the traditional tools of construction, the regulation is genuinely ambiguous. A court must carefully consider the text, structure, history, and purpose of the regulation before resorting to deference. If genuine ambiguity remains, the agency's reading must still fall within the bounds of a reasonable interpretation. And even then, not every reasonable agency interpretation of a genuinely ambiguous rule should receive Auer deference. Rather, a court must also make an independent inquiry into whether the character and context of the agency's interpretation entitles it to controlling weight. The inquiry across this dimension does not reduce to an exhaustive test, but the court has laid out some especially important markers for identifying when Auer deference is and is not appropriate. To begin with, the regulatory interpretation must be the agency's authoritative or official position rather than any more ad hoc statement not reflecting the agency's views. Next, the agency's interpretation must in some way implicate its substantive expertise, as the basis for deference ebbs when the subject matter of disputes is distanced from the agency's ordinary duties. Finally, an agency's reading of the rule must reflect its fair and considered judgment. A court should decline to defer, for example, to a merely convenient litigating position, or to a new interpretation that creates unfair surprise to regulated parties. Stare decisis cuts strongly against overruling Auer. Adherence to precedents is a founding stone in the rule of law, and any departure from doctrine demands special justification. That is even more usually so in circumstances here. First, Kisor asked the court to overrule a long line of precedents, each one reaffirming the rest, and going back 75 years or more. Second, because Auer deference pervades the whole corpus of administrative law, abandoning it would cast doubt on many settled constructions of its rules. And third, even if the court is wrong about Auer, Congress remains free to alter what Congress has done. For approaching a century, Congress has left this deference regime work side and side with both the Administrative Procedures Act and the many statutes delegating rulemaking power to agencies. This court would thus need special justification to now reverse Auer. Kisor offers nothing of the ilk. Nearly all his arguments relate to whether the doctrine is wrong or poorly reasoned. He does not claim that Auer deference is unworkable, a traditional basis for overruling a case, or point to changes in legal rules that make Auer a doctrinal dinosaur. Instead, his lone special justification is that the administrative state has evolved substantially since this court decided Seminole Rock in 1945. It is true that agencies have far-reaching influence today. This is one reason the court has taken care to reinforce the limits of Auer deference. But it is no answer to the growth of agencies for court to take over their expertise policy-making functions. Turning to Kisor's own case, a remand is necessary for two reasons. First, the Federal Circuit jumped the gun in declaring the VA's regulation ambiguous before bringing all of its interpretive tools to bear on the question. Second, the Federal Circuit assumed too fast that Auer deference should apply in the event of a genuine ambiguity, rather than assessing whether the interpretation is of the sort that Congress would want to receive deference. On remand, the Court of Appeals must consider whether Auer deference is warranted, bearing in mind the principles just outlined in this opinion. This opinion by the court was a very fractured opinion, had many different opinions with different parts controlling. So let's just review what parts controlled for which parts. First, it's very clear that parts 1, 2b, 3b, and 4 are the majority opinion because you have 5 justices signing up as to those parts, and Kagan wrote that part of the decision. With respect to parts 2a and 3a, only 4 justices joined. Roberts also filed a concurring judgment. Gorsuch filed an opinion in a concurring judgment in which Thomas and Kavanaugh joined as to parts 1, 2, 3, 4, and 5, and which Alito joined as parts 1, 2, and 3. Kavanaugh filed an opinion concurring in the judgment in which Alito joined. Sometimes counting votes in Supreme Court decisions is very hard. Where you have 5 members of the court, that's pretty easy. But where you don't have 5 members of the court, you have to look for overlapping parts of the opinion. So while there are parts of this opinion that clearly have 5 members, that doesn't mean that's the only controlling parts of this case. You have to look to the other concurring opinions to see if there are 5 justices that would agree as to the broadest possible grounds. And that's where things get exciting for future litigants as they're trying to count votes to look for things that might favor their position. However, despite these difficulties, we do have a very clear bottom line as to this case. When an agency is interpreting its own rules, as long as it's applying its subject matter expertise, the rule concerns its subject matter expertise, the rule is broadly and ambiguously drafted, and the agency has a reasonable interpretation of the rule, the court says that the agency should get its interpretation to be upheld. So they're upholding it with respect to this particular issue at hand and sending it back to some further judgments to see if, in this particular case, Kisor should win the case or Kisor should lose the case because the Court of Appeals to the Federal Circuit didn't fully do a full legal determination. So it's unclear at this time whether Kisor will win his money or not, because the Federal Circuit has more work to do, but what is clear is that they should give deference if all those conditions apply, and that is a legal question that they're going to have to analyze when they get this case on remand. This case is also a bit of a surprise. The general consensus had been that the Supreme Court was going to overrule Auer deference. It has been something that has been controversial in conservative circles for quite a long time. So it is somewhat surprising that the Supreme Court didn't go that way and overturn Auer, but it is upheld for the moment. However, the justices did make very clear that this has in no way any bearing on a case called Chevron, which is even more hated by many people. Chevron deference says that agencies get deference with respect to statutory interpretation questions, not just rulemaking questions. And this has been deeply criticized by many conservative members of the court and is criticized in this opinion by conservative members of the court. This case did not touch on Chevron deference because this case did not involve an ambiguity in a statute, merely an ambiguity in a rule, so Auer applied. But if the case should come where an agency is interpreting a statute, we're going to see whether or not they're going to overturn Chevron, and as for that, I feel reasonably confident they are. But until that day comes, this is all for now. Until later, my friends, I hope you're well. Later, cheers, and goodbye.